Never doubt that a small, thoughtful group of concerned citizens can change the world, because indeed, that is the only thing that ever has. A very good evening and welcome to another edition of The Role of Law. This week, our topic of discussion, of course, is related to the environment, the world that is common to us all. Especially here in Sri Lanka, we saw a flurry of news pointing towards environmental destruction, specifically deforestation. Now, when we speak about environmental laws in Sri Lanka, we have many pieces of legislation that governs environmental laws in Sri Lanka. Too many, of course, to compact into a simple half an hour program. So we decided to focus only on the issue of deforestation, since that is the main issue that we have been speaking about these days in the current times. And of course, to discuss that, we've got the best person in Sri Lanka on our show. He is attorney at law Jagath, Gunawardena, a friend of our network. Thank you very much, sir, for joining us on our show this evening. And sir, getting right into the topic, before we get into our discussion really, let's take a look at some of these incidents that we will be discussing on our show, The Role of Law, today. We will be discussing the impact that this has on our environment and, of course, more centrally, how the general public, our viewers out there, can contribute to stop this environmental destruction.
This is the manner in which 5 acres of land in the lower Panvilla area in the Knuckles Forest Reserve have been cleared recently. Upon inquiries made by Forest Conservation Department officers in the area, it has been revealed that the land had been cleared to commence a vegetable cultivation. Forest conservation officials said that individuals involving in clearing the land had claimed that the area was owned privately. However, they did not have any legal documents to prove their ownership. Regional officers of the Forest Conservation Department said that their records do not indicate that the land area had been owned by a private entity. Environmental organizations say that it is surprising that no institution has been made aware of the activities taking place in such a highly sensitive ecological zone.
Road construction work to expand the road bordering the Singharaja Forest, which is a World Heritage Site, commenced in the first week of August. The Forest Conservation Department said that an 8 feet wide road currently exists in the area and that it is being expanded to 12 feet. This was with the involvement of the Sri Lanka Army and the Road Development Authority. Dr. At-at-Law, Galle District Forest Officer, said that this road, which is being constructed on the border of the Singharaja Reserve, includes about 1,300 meters of the reserve in 3 places. He said that the Road Development Authority has requested to construct a road across the reserve last week. The Galle District Forest officers who conducted the study have informed the Forest Department about the recommendations. They recommend that the construction be carried out in a manner that minimizes damage to the ecosystem.
These scenes depict the previous condition of the Ramsar wetland in Arnavilundava in Puttalam. Around an acre of land in the Muthupanthia area has been destroyed at present. The Arnavilundava area, that includes a water tank system, is an important wetland under the Ramsar Convention. However, the Arnavilundava Ramsar wetland, that is of significant importance, has now fallen prey to a group that is attempting to destroy the environment. Approximately an acre of the wetland in the Muthupanthia area that falls under the purview of the Forest Conservation Department has been completely razed. The destruction had taken place amidst moves to restore the mangroves in the area. Although it has been revealed that the area was razed to build a pond for shrimp farming, it remains questionable as to who had permitted such activities. A startling revelation is that the Forest Conservation Department, that had been overseeing the Arnavilundava wetland, was not aware of this activity.
Environmental resources are considered as public property. The state has the overall responsibility to protect the environment. Even when a land is owned privately, there are particular environmental resources upon the land
which the owner does not have the legal ownership of. These could include protected trees, animals, certain minerals, and all streams and rivers. Sri Lankans have a constitutional right to a healthy environment. Article 27, Sub-Article 14 says the state shall protect, preserve, and improve the environment for the benefit of the community. This is a directive principle of state policy. Article 28 of the Constitution imposes a duty upon all citizens to the same effect.
Attorney-at-Law Jagath Gunawardena, now we saw these issues, and how does this really affect the people, and how are the people involved in protecting the environment? How should the people be involved, and what are the legal provisions or the legal measures that have been put in place to allow people to get involved in protecting the environment?
There are several laws where direct public participation or direct public involvement is possible, but everyone has a role to play in the protection of the environment, a right that is even given in the Constitution of the Democratic Socialist Republic of Sri Lanka. According to the provisions of Article 28, everyone owes a duty and responsibility in protecting the environment. So each citizen has a duty and obligation to protect the environment, but many people are not aware of this provision, and some of those who are aware of it are also doing nothing. But of course that duty is there, it's an obligation on the part of us, but there is a deeper obligation because we owe this right and duty towards the next unborn generations. So we have to think about the unborn generations, or maybe our own children, when we think of the environmental destruction, and see our duty and obligation to protect it for their sake at least.
So when you say that people are really not aware of these provisions and how to, you see people campaigning against deforestation, but we see a little bit of a political element in these campaigns. Do you believe that the people who actually say that there's deforestation here, there's deforestation there, are speaking with an awareness regarding the subject matter, or are they just repeating empty rhetoric?
Nowadays, information is very much flowing in the society thanks to the social media and the technological advancements.
Right.
So unlike in those days, now anyone can make a video, or they can even take the positioning of the incident and see whether it's a privately owned land or a state land or a forest land, and therefore the facts are now free for all most of the time, and social media carries them very much afar. So judging by the recent incidents, I should say that most of the incidents that I had looked into are real incidents, which is very unfortunate and sad, but they are all true which I have looked into. I couldn't say I had looked into each and every incident that appeared in the social media. I have missed some maybe, and I didn't have the time to look into each and every incident, but what the social media has said is a major incident. I had taken my time to look into it to see that they are all unfortunately true.
We have also seen incidents where people claim that this area that is in a forest or in a protected area is their private land, and that they can do whatever they want on it. Is there any basis to this argument?
There can be private land only inside sanctuaries that are declared under the Fauna and Flora Protection Ordinance, or in an environmental protection area declared under the provisions of the National Environment Act. Okay. All other protected areas have only state land. So if someone claims that it is a private land in the protected area, we have to look into their claim, and most of the time we find that they are false claims or fraudulent claims.
Let's now take a little bit of a look at how the law protects natural resources, and what specific natural resources does the law really afford this protection to?
How does the law protect natural resources? Land and resource use in ecologically sensitive or protected areas are governed by a series of regulations. All landowners, both public and private, are required to take measures to prevent or control erosion and to mitigate against damage by floods and drought. Use of land for agricultural purposes can be restricted by the Ministry of Agriculture Development which can also control the exploration of forests and grassland resources in erodible areas and also give directions on what type of crops can be grown. Mining can only be carried out with a permit which must be obtained by the Geological Survey and Mines Bureau.
Attorney Law Jagath Gunawardena, when we see, especially since our discussion here is focused on deforestation and the harms that have been caused to these forest reserves, these sanctuaries, one of the main arguments put forward by the authorities or the people who are engaged in these deforestation activities that this is being done for development purposes. Are you asking us to stop developing the country? What's your response to this?
My response to it is twofold. The first thing is that development has to happen in a rational manner where the development will prevail in the longer run. If it is economic growth in the short term, I won't call it development. The second part is about the land. Now many people claim that they have to utilize forest for development, but we all know that about 17% of the land mass of the country is still covered by the natural forests, including mangroves.
This is in Sri Lanka.
In Sri Lanka.
17% of the lands are forests.
Approximately, yes.
Approximately. The remaining 83%?
83% is not forest land, but it may include cities, it may include cultivations, it may include barren land or marginal land or whatever it is.
Right.
So my simple question is, are we locked in the past or are we looking at the future? Because if we are locked in the past attitude was to utilize forest land for development activities, and that attitude came at a time when the majority of the land mass of this country was comprised of forests. So that is the 19th century attitude that forest land can be gainfully used for development activities. But now we have come to a stage that not even the minimum 25% of forest cover is not there anymore in this country. So my question is, now the majority of the land is cleared for whatever purposes. Shouldn't we, at least at this latter stage, have a land use plan where we look at the current land use patterns and find out land for all these other activities from the 83% rather than going for the diminished 17%, which is going to get diminished in the long run if we try to make use for other things. So we are at a position where we have to increase the forest cover if we want to keep the life cycles going at a reasonable rate, but we are working contrary to the system. So my thinking is, we are still locked in the past. If someone argues that we need forest land for development, I am sure that person's mindset is locked in the past. If they are looking at the futuristic sense, they will look at the 83%, divide the land into the patterns that are being currently utilized and find land for other purposes from that 83%, because anyone, even a small child, can discern the fact that 83% is several times larger than 17%.
Of course, the argument that you presented is, of course, for the consideration of our policymakers, who are the current government of Sri Lanka. However, drawing a little bit more focus towards the legal provisions that have been put forth to protect the environment. And as you mentioned at the beginning of the program, it's not only the responsibility of the state. Citizens have a responsibility as well to protect the environment. And before we can educate our public on what exactly they can do to protect the environment, or if they see something happening, a destruction of forests per se, what really can they do? Let's take a look at some of the legislation that affords different sorts of protections to natural resources here in Sri Lanka.
Environmental protection comes under the jurisdiction of various institutions to whom the state has delegated the power through various legislation. These legislation include the Forest Ordinance, which consolidates laws relating to forests and to the felling and transport of timber, and establishes other state lands and forests where even commercial use is permitted. The Flora and Fauna Protection Ordinance makes provisions to protect and conserve fisheries and aquatic biodiversity in marine and freshwater areas. The National Environmental Act establishes the Central Environmental Authority, defines its powers, functions and duties, and how it interacts with other agencies to ensure environmental management. It provides umbrella environmental protection legislation sets up licensing procedures, environmental standards and project approval procedures. The legislation allows the Central Environmental Authority to prosecute and enforce environmental safeguards. The National Heritage and Wilderness Areas Act focuses on declaring and protecting important wilderness areas. Sri Lanka has also underlined its commitment to a clean and healthy environment by subscribing to a number of international environmental conventions.
So those are just a few of the legislation that really afford these different sorts of protection to natural resources in the country. We were mainly speaking about forests. So let's start off with the Forest Ordinance. How does the Forest Ordinance afford protection to forests here in Sri Lanka?
The Forest Ordinance is the oldest piece of legislation when it comes to the protection of habitats in Sri Lanka, and the Forest Ordinance gives protection through a series of protected areas. The highest degree of protection is given to conservation forests. Then the next degree comes for the reserved forest or the forest reserves. Then there was a type of forest called village forests, which were maintained for the sake of the communities in the area, but those village forests are not there in the ground anymore.
Right.
But there is another important provision in the Forest Ordinance which gives protection to all state land, irrespective whether they are under the Forest Department or not. Any state land that is not otherwise protected either under the Forest Conservation Ordinance or the Fauna and Flora Protection Ordinance or under the National Heritage Wilderness Areas Acts are protected by the Forest Conservation Ordinance. So this provision to protect any other state land is one of the most vital provisions in the Forest Conservation Ordinance, as I see, and the provision is section 20 of the Forest Conservation Ordinance. So it plays a major role in protecting many habitats which are not inside protected areas yet.
Right. So moving on, the Flora and Fauna Protection Ordinance, what sort of protection does this piece of legislation afford?
The Fauna and Flora Protection Ordinance also gives protection to habitats of wildlife by making them into protected areas. There are three main types of protected areas. National reserves, which also comprises of 7 different types of protected areas, and sanctuaries and managed elephant reserves, but unfortunately we still have not got even one managed elephant reserve in this country. Although the provision is there in the law for the past 12 years, it has not been made use of still. But we have a lot of sanctuaries and a lot of national reserves, and there are 7 types of natural resources, and out of the 7 types of national reserves, there are 5 categories which have land in the ground. So most of these are either national parks or nature reserves, but there are other types like the jungle corridors and the marine national parks, which can declare both marine environment and adjacent land mass.
There are of course a number of institutions in Sri Lanka to enforce these pieces of legislation, and one of those main institutions is the Central Environmental Authority. The Central Environmental Authority is established under the National Environment Act. So what is really the importance of this act when it comes to the protection of the environment?
The National Environment Act is basically landmark legislation for the reason that it used science very much as the basis for protecting the environment. It was mainly geared to protect the physical environment, but of course there are provisions like declaring environmental protection areas that can even help protect biological diversity directly. And it has been made use of to declare certain areas with outstanding biological value, like the Waratanna Hatkinda Environmental Protection Area and the Walawatha Waturana Environmental Protection Area, which have some outstanding biological value. But mainly the act is focused on maintaining the quality of the air, the quality of the water, the quality of the soil, and also to keep the society free from unnecessary and unwanted sounds and vibrations, which may also cause problems for the environment. So it's basically an act that is meant to keep the physical environment in a habitable condition.
As far as the establishment of the Central Environmental Authority goes, how significant is it?
It's a significant development because what I can look back is that when the Central Environmental Authority was created in 1981 under the National Environment Act, which was passed in 1980, many people said that such an authority is not needed because there are nothing significant to tackle by such an authority. But I think it was a very far-sighted move. It was a preemptive move, because when the industrialization came, the law and the regulations were at least in place, and it is significant to note that after some time they realized that even that was not adequate. So it was amended drastically in 1988, bringing in a lot of provisions that helped to deal with the pollution of the air, water and soil, amongst other things. So that was what I call a preventive and preemptive legislation, where they prevented some unwanted things from happening by having the legislation first before the rapid industrialization happened in the early 1980s. So it's a significant piece of legislation for several reasons, and another reason is that it brought in science in direct contact with the law, because it's a scientifically accepted criteria and norms that are to be given by way of regulations to regulate the outflow or the release of effluents to the environment, that really regulated by the Act. So it was a significant piece of legislation, and it was a foresight on the part of the authorities to have such a legislation before industrialization took on rapidly.
Now, a real contentious topic that we've been discussing for quite a long time is the Singharaja Forest. There was a road being constructed along the borderline of the Singharaja Forest. Of course, there were calls from environmentalists, especially saying, stop the destruction in the Singharaja Forest, stop the construction of this road. But then there were also calls from the people living in these villages saying, we don't need environmentalists, they really push us back from development. So we need a road, and that is what is being constructed right now. But before we get into the real substance of this area, the Singharaja Forest, is specifically protected under the National Heritage and Wilderness Act. Could you highlight the significance of this act and what does it really do?
The National Heritage Wilderness Areas Act is to give protection to very significant areas of biodiversity and other values. And Singharaja was the first and the only area in this country that was declared under the National Heritage Wilderness Areas Act, and it was subsequently accepted as a World Heritage Site by the UNESCO, giving it more significance and prominence.
Right.
And Singharaja is a sensitive ecosystem, and an ecosystem is a complex body where so many processes, both living and non-living, interact with each other to form this complex. So touching a complex environment like the Singharaja, which is a wet zone forest, is rather a risky thing. And at least to mitigate certain amount of risk, there are various procedures and various legal tools available. And one legal tool that is time tested in Sri Lanka is the environmental approval process under the National Environment Act, which deals with areas that are declared under the National Heritage Wilderness Areas Act, and any project that comes within that area or falls within 100 meters from the boundary of such a declared area needs to be subjected to an environmental approval if it is one of the prescribed projects. So a road construction is a prescribed project that needs approval from the Central Environmental Authority, and such approval has to be preceded by a environmental impact assessment report or EIA report, or an initial environmental examination report or an IEE report. So the EIA is the most comprehensive type of report, and if it is a sensitive ecosystem, my personal view is that it should be subject to a deep analysis like environmental impact assessment. So our contention on this issue is that necessary environmental approval was not sought before the roadway was built, and there was no haste to build this road because the people are not there from recent times. The people were there for a long time, so there was more than adequate time for the authorities to consider doing an environmental study and assessing the best course of action that they could take. Because the heart of the environmental impact assessment is the looking up for alternatives. So in this kind of a situation, the alternative is the alternative routes to reach this village and link it with another village. So I am still in doubt whether what is being done is the best possible alternative, or if there was an EIA, there was at least a possibility in looking at the alternatives deeply and coming up with a suitable mitigation action plan before the work commenced. So once the work commences, the destruction invariably happens, and without the mitigation plan, the destruction will be manifold rather than working with a preconceived mitigation plan. So that's where the fault lies. And that's where the environmentalists are having loggerheads with the authorities over this matter.
So deviation from due process is of course a violation of the laws that this country is based on. But when it comes to these matters especially, it's very important that the people living in these areas know how to react when they face such an incident, when they see environmental destruction happening before their eyes. Do you really know what you could do, or what you should do more importantly, if you see an incident where environmental destruction is taking place right before your eyes, if you know of any environmental destruction taking place in and around your surroundings? This is what you can do.
There are three main mechanisms through which you can lodge and address environmental complaints: through reporting to the police, taking a case to court, through mediation and negotiation. You can file a complaint at the police as an individual or as a group. Gather as much information as possible to back up your complaint, such as an accurate description of the location and the type of activity that you think may be illegal. If you know the authorities that deal with the activities about which you are complaining, then you should also bring it to their notice in writing. You can always check up on the progress of the complaint that you filed at the police. How to take a complaint to courts? First, you need to make a complaint to the police. This is because a police report will be required in order to file a private suit. Once you have a police report, then you will need to retain a lawyer to take the matter to court. There are a number of organizations that offer legal services pro bono, especially for matters concerning environmental protection, and you can always contact them for legal representation in such matters. How can you undertake mediation? All divisional secretariats carry out dispute mediation. You can take your complaint to the divisional secretariat and ask them to help with mediation. They may call the two parties to discuss and resolve the matter. However, they cannot give a legal ruling. Also, in mediation, the two parties must be willing to take part in the discussion and to reach an agreement.
So those are a few ways that the people can really take matters into their own hands and alert the authorities especially about this environmental destruction that's taking place before their eyes, and take measures to, of course, stop it. Let's speak a little bit specifically about the practical issues that the people might face. Let's start off with, in your view, sir, out of these measures that can be taken when environmental destruction is taking place by a third party, bystander, what should be their first course of action?
Their first course of action would be to alert the authorities about the destruction. We all know that most of these institutions, including the Forest Department and the Department of Wildlife Conservation, are severely short of staff.
Right.
So they may not be present in every situation that arises.
So when you say alert the authorities, do you mean the relevant institution that is in charge of that forest, or can we just go to the police?
Anyone can go to the police, because the police, under the provisions of section 56 of the police ordinance, are empowered to act against any offence in this country. In addition, they can alert the Forest Department or the Wildlife Department, as the case may be. But if they are unable to find out which authority has the power over this particular area, they can always call the police or even go and make a complaint to the police. Now the procedure had become simplified, because they can always call the police by one of these numbers and alert the police about this incident. And that's one small responsibility as a responsible citizen of this country, to alert the authorities of an ongoing process. In addition, they can also alert the Central Environmental Authority about it. But I think the police and the Wildlife Department and the Forest Department, as the case may be, are much more well equipped to deal with such a situation, because according to the provisions of the Fauna and Flora Protection Ordinance, offences inside protected areas are cognizable offences, where the police or the Wildlife Department or the Forest Department, either from one of the three institutions, can take the persons into custody without a warrant even.
Right. However, you said it's a small part of the responsibility on behalf of the general public. What if I tell you it's not as small as it sounds? Because people are really putting themselves at risk when they alert the police. There was a recent incident where certain parties of the authority were alerted regarding an environmental destruction that is taking place. And what we heard the very next morning, the people who were responsible for this environmental destruction had gone to the house of the person who alerted the police and threatened to kill them.
I have come across such instances, and our advice was to go to the police once again and make a complaint, because it may be tantamount to criminal intimidation in such a case, and there are provisions in the penal code to deal with such kinds of intimidation against people for making their claims. But this is one way of intimidating people into silence, and it is a process that is not unique to Sri Lanka, but happens in many parts of the world. We call them actions to prevent public participation in asserting their rights.
Right.
So they have to take drastic action, and the authorities should also be sensitive about the complaints received by the public in such instances, and not take the side of the people who are powerful.
So there is also another option on the part of the general public, mediation and negotiations. Is this widely used in Sri Lanka? Is it used at all?
Mediation and negotiation can be used in certain instances, but not in cases of destruction of public resources like the forests or wildlife. But it could be gainfully used in cases like pollution happens from a factory or an industrial venture.
Okay.
Mediation is somewhat successful in some instances, and in some instances mediation is successful after the case had been come before the courts, and when one party realizes that there is a deadlock, especially the polluter realizes that there is no way out but to compromise. My personal view is that most of the mediation efforts fail because the people's egos get in the way. So that's my view, and because people put their egos before their real needs and wants, people don't want to negotiate, because they think that it's a sign of weakness to negotiate or mediate. So they think that litigation or taking drastic action is the powerful way, and mediation is the way of the weak. But my personal view is that mediation should be the first action when it comes to such a situation. Negotiation would come next, and going to court should be the last option in the arsenal of methods. Though I am a lawyer, I always think that there are other things, and once these things are exhausted, only that we should go and seek redress from the courts.
So let's speak about the last weapon in the arsenal
Yes.
of a litigant, going to courts.
Yes.
How can a member of the general public really take this matter to courts?
There are various ways where a person can go to the courts, because there are some enactments where people are allowed to directly go to courts, like the Fauna and Flora Protection Ordinance, which has section 60E, that makes it possible for any member of the public to go to courts if the authorities don't take action after they duly inform the authorities of a transgression.
Although the protection of the environment has been
Yes.
in the Constitution defined as a right of the general
Yeah,
public,
that
it's
right-
not really justiciable, is it?
Yeah, it is not justiciable, but now it has come to be justiciable under the various
Case
laws, and especially the Chunnakam case law,
Dear
which made it linked to Article 12(1) of the Constitution, which gives
Right.
legal rights to the people, and also people can seek redress by way of the writ actions and fundamental rights petitions, both of which will compel certain government authorities to take appropriate legal action. In addition, there will be civil actions to prevent some harm, or actions in the magistrates court under the criminal procedure code or under different enactments, where people can make a direct appeal to the court and get some redress when there is a problem. And there is also provision in the penal code to take action against officers of the government who negligently refuse to carry out their duties and obligations. So that's also there as a weapon to the public.
Attorney At-at-Law Gunawardena, we've really had a fruitful conversation here today. We're in the final few minutes of our show. In a time where environmental destruction is almost being reported on a daily basis, when we sit here at Newsfirst and report on these matters, it really brings tears to our eyes. And I'm pretty sure it's the same story for the general public as well, especially environmentalists, people who love and cherish the environment, as we all should, as the people of Mother Lanka. What is your final words of advice to our viewers out there who have to go through this? What can they really do? How can they help to stop this?
Well, my personal view from the legal perspective is every one of us is given the same right and obligation under the law to protect the environment. So, it is not the duty of the people who are claimed to be environmentalists. I personally do not call myself an environmentalist. I care for the environment and I do more than what is expected out of my duty and obligation, and therefore other people may call me an environmentalist, but no one can say or relegate the duty of protecting the environment to the authorities and the environmentalists as they call us in the collective sense. But everyone has a duty and obligation. Try to do your duty, try to fulfill your obligation, at least in some sense. Yeah, you have some power. Everyone has some power. No one is absolutely powerless, but many people do not perceive the power that they have. So, tap this inherent power that is bestowed on you and try to do something, and if many people get together and try to do something, they can move even mountains. We know that a small dedicated group of people can do a lot, and that is time tested in different arenas in the world, where a small dedicated group of people had always pushed through obstacles. So, that is my message in parting.
Well, just like you said, sir, alone we can do nothing, but together we can do much. And thank you very much, sir, for coming on our show this evening and really educating the people regarding their right, especially when it comes to the environment. It's a very important aspect. We cannot buy it from the market. Once we destroy it, that is the end of it. And coming back really from environmental destruction, reeling back the time from years of environmental destruction is almost near impossible, and it is our duty to ensure that environmental destruction does not take place to begin with. Once again, thank you very much, Attorney-at-Law Jagath Gunawardena, for joining us on our show this evening, and thank you very much, of course, to our viewers. That's it from the Role of Law for today. We will see you again, same time, same place, next week. Until then, take care and God bless.